Okay, we're going to get started. I'd like to welcome everyone to this town hall session with 3 of our Davidson County Chancery Court Chancellors. We have with us today Chancellor Ann Martin, who presides over Part 2 of our Davidson County Chancery Court. We have Chancellor Pat Moskal, who's in Part 1, and then Chancellor Russell Perkins, who's in Part 4. Chancellors, welcome, and thank you so much for being with us today.
Thank you.
Happy to do it.
I'm going to start by posing just a broad question to all 3 of you about how your courts are adjusting in light of the Supreme Court order that is prohibiting in-person hearings. And since we have multiple judges on with us today, I'm just going to actually go through each one of you and identify who should answer first. So we'll start with you, Chancellor Perkins.
Well, before the order came out and we knew something was coming, we started trying to cancel our evidentiary hearings because we kind of thought that in-person hearings would be postponed. So we did that. So we don't have any in-person hearings at all, but no evidentiary hearings set up for the next couple of weeks. We have been hearing all of my matters by telephone. And we have a temporary injunction, in fact, which is non-evidentiary, scheduled for telephone hearing. We might switch it to Zoom. But that's basically it. We've just been doing our motion docket by telephone. Instead of having everybody on the phone at the same time, we are staggering the hearings so that we have one hearing on at a time. And usually it's a small number, 4 or 5 hearings on a given Friday. So that's where we are right now. I have scheduled a few jury trials over in the fall. That's my hope that we'll be able to do those then. But that's it.
Chancellor Martin.
Thank you. So I had my first motion docket by teleconference after the first Supreme Court order came down on the 13th of March. After that first week, I've done them all by video and have done a couple of other hearings, either motion hearings that were specially set or some injunction hearings by video conference, and it has worked really, really well. I'm using the WebEx system, which is what the AOC is using and provides support for. I did use Zoom for one hearing. I had one hearing where we had a press request and we needed to be able to live stream the hearing to make it available to the public. And the WebEx, this is what we found after a lot of really smart IT people sort of worked together between the Davidson County Trial Courts folks and the AOC folks, that the WebEx system does not have the capability to live stream through YouTube. So we did use Zoom for that and found that to be very successful as well. I find that people really do like the video conferencing, and we're doing with the motion dockets is trying to anticipate what time we would start each motion. And so Ms. Broadnex, my calendar clerk, will notify people and say, we're going to start you at 10:30. We're going to start you at 11:15. And if we go over on something and people log in, we can see them, and sometimes we'll let them sort of hang out because we're almost done, or if we think it's going to be a while, I can let them know to call back in at another time. And that seems to be working really well and be a good use of people's time.
Chancellor Moskal, how have you adjusted in your courtroom?
Well, very similar to Chancellor Perkins and Chancellor Martin. We postponed all of our scheduled evidentiary hearings in March and April, and we're now reviewing May. And if they are evidentiary, I am not hearing those at this time, and we'll just have to see how long that continues. We are anticipating additional guidance from the Supreme Court probably early next week, and so there may be some adjustments after that. I also am hearing all motions, emergency injunction hearings, and any other type of hearing except for evidentiary hearings by either teleconference or video conference. I've used both. And I'm trying to send notices out a week ahead of time to let people know that you've got a motion pending on the motion docket. We will be conducting that by teleconference. You will receive by email, because we want to make sure we have everybody's email. You will receive the dial-in number the day before the hearing and a time to dial in, because like Chancellor Martin, I'm trying to stage and stagger the motions to keep people from having to sit through an entire motion docket. So that's worked pretty well so far, and we've been able to anticipate about how long the motions are taking. I'm also doing status conferences and scheduling conferences by teleconference, and those have worked well.
I can't help but notice that all three of you appear to be in our courthouse. Are you holding any in-person hearings whatsoever right now?
No.
Not at all.
Some of them, go ahead, Chancellor Perkins, I'm sorry.
I just said no.
Okay. The Supreme Court's order did include exceptions for certain emergency matters. Are you handling emergency matters, and how are you doing that?
Yes, you know, like a TRO or something. Typically, it's non-evidentiary. Same thing with a temporary injunction by virtue of Local Rule 19. And so the default position for me is to have it non-evidentiary and have it decided on affidavits and cognizable written proof. I had an emergency hearing yesterday about telephone with some lawyers. It was non-evidentiary. So far it's worked out, but you know how it is. After a while, people are gonna need evidentiary hearings, and we're gonna have to figure that out as we get more guidance from our Chief Justice.
And what I would add to that is, because of the nature of Chancery Court practice, while things are time sensitive and none of us intend to slow down things, and as far as I can see, things are not slowing down other than the evidentiary hearings because of the inability to have people in person. It is different from some of our colleagues in other courts who, you know, like the judges who hear matters that are orders of protection or criminal matters where those cannot wait, and there are some exceptions in the Supreme Court rule about what can be in person and what can't be, and they have had to put in place restrictions about how many people are in the courtroom and how things are staged. But we are really in a fortunate situation where we really can control that and keep things moving without having in-person hearings, but getting to the final evidentiary hearing, that has been difficult under the current circumstances, and we are all going to have to figure that out going forward. And the availability of civil jury trials, I don't know what that availability is going to be perfectly frank, because there's going to be a backlog of criminal cases, and those really have to take priority.
And I was going to ask about backlog with not having evidentiary hearings right now, and also Chancellor Perkins mentioned jury trials. How many matters have been kind of postponed or had to be continued, and how do you anticipate handling any backlog?
Well, initially, this is Chancellor Moskal. I continued my evidentiary hearings indefinitely, and we're keeping a running list of those. So as soon as we can restore in-person hearings, we can get those back on the calendar as quickly as possible. In terms of numbers, I've probably postponed about half a dozen matters that were evidentiary during the second half of March and April, and we're still assessing May at this time. We don't want to get too jammed up, and so I want to continue to do as much as we can by video conference. I have not yet decided to move forward with video conferences for evidentiary hearings, but I know some judges are in Davidson County, and so we will be evaluating that as we move forward.
Chancellor Martin, Chancellor Perkins, do either of you want to add anything to that answer?
I don't have much to add, but I did postpone. We looked ahead on the jury trials and we postponed some of those, 1 or 2 of those in May. So we're really trying to get a little, additional. The Tennessee Supreme Court has been really great about getting those orders out and helping us figure out what we should and should not be doing. And so when the next order comes out, we'll be able to decide whether we should go forward with video conferencing for the bench evidentiary hearings. But right now, I don't have any evidentiary hearings set.
For me, I think I had to push 4 or 5 bench trials that we have reset, I think in July and forward, and they were 2-day matters, 1 to 2 day matters, or maybe there was a 3-day matter, but those were easy enough to set. My first jury trial, I think I have on the schedule right now, is either August or September, and I'm keeping those on the calendar for now. Again, we're going to be looking for guidance about when jury cases are going to start and what the priorities are. Typically what happens is at the beginning of the calendar year, we all have jury weeks allotted to us. So we know when we're scheduling, if you want a jury case, you can do it this week in August or that week in September, that kind of thing. And that's how we schedule. I don't know if that's going to change, but we're keeping that all on the calendar and are going to be waiting for guidance.
And I would add to that, Laura, that when we do start in-person hearings again that are non-jury, each judge, I think, is evaluating their courtroom to come up with at least a working plan for the moment as to how we can maintain physical distance with the attorneys and the witnesses that may need to testify. And so it's not going to be a one-size-fits-all, as our Chief Justice has said, but we're in the process of thinking that through so that we have a plan that we can work with when that time comes.
And that's actually a great segue to my next question, which is anticipating that at some point we're going to have some in-person proceedings resume, maybe not all at once, but as we start to add back in-person hearings, what sorts of things are you thinking about adding in to your procedures to assure social distancing? For example, are you going to require masks in your courtroom? What about gloves? Are you going to keep witnesses out in the hallway? What sorts of things are you thinking about in that regard?
All of the above.
Absent guidance to the contrary from our Supreme Court, we may actually have plexiglass barriers for some period of time in our court and in Part 4, and it's going to vary from court to court because I think many judges do not want the barriers, and we're probably really going to need to hear from the bar about that. If somebody feels really strongly about it or has some insight on it, that'd be good for us to consider while we're trying to make up our minds about what to do. But I have preliminarily decided that I do want the plexiglass matters. In Chancery Court here in Davidson County, we don't have court officers. And so if somebody comes in there pro se and decides to take off their mask, I'd feel better if we had some kind of physical barriers while we're trying to get some instructions to that person. So that's my preliminary thought.
And the judges, we've all been emailing and talking about different ideas. And, it is different if you're on the 4th floor versus being on the 5th and the 6th floor of this courthouse. There are a lot more people on those floors than on our floor, but we have smaller courtrooms and have lower ceilings and the hallways, don't seem as wide and so forth, versus our colleagues in the Birch building. They have more staff because they have more people to manage, including inmates. There has been discussion about asking people to wait out in the hall until their case is called. But again, as Chancellor Perkins said, we don't have a lot of extra hands to manage that, but we also don't have as big a dockets or as many people outside of our courtrooms and inside of our courtrooms on a motion docket. So I think a little bit of it's going to be trial and error. And I like the idea of asking the bar for what their preference is and what people's comfort levels are, because I think that's going to be varied.
I'm taking notes so we can poll our members at some point about their preferences for you and hopefully provide you some good information on that.
And we anticipate continuing video conferences and telephone conferences too. Evidentiary hearings may be different, but you know, we're not going to discontinue using those. We're going to, I see a heavy use of those technology means going forward.
Some of the other judges that we've had town halls with have commented just on the decrease in overall traffic in the courthouse. What have y'all seen at One Public Square? How many people do you typically see coming in and out of the courthouse, and how many people are you seeing now? And I'll open that to any of the three of you, if any of you has an idea.
Personally, I'm not seeing anyone. I'm sure the clerk's office is getting some traffic down there, but I'm not seeing anyone at this point.
Yeah, for people who don't realize, we park and secure parking and come in under a tunnel and then come up in what they call the executive elevator to our chambers. So we are truly in a bubble. The chancellors have all spent a lot of time talking about how to keep safe. Our clerk's office and Maria Salas has done an amazing job of juggling staff, cross-training, having shifts of people working different days, figuring out a way to keep people out of the clerk's office, but still be available to the public. They have a drop box for filings. There are special challenges to the clerk and master's office, like taking delinquent tax payments, and they have worked out ways to do that by phone, which they had not previously done. So I would say that as judges, that's not as much of an issue for us as the part of the court system that really serves the public and interacts with the public, like the clerk of master's office.
And it's for that reason that we are really encouraging e-filing and fax filing. The clerk and master is using a Dropbox filing for any paper filing, but it will, we're checking them once or twice a day, processing that paper and date stamping it on the day that it's received, but you may not receive your stamp file copies back until the next day if you want to pick them up, or they can always be mailed to you just to minimize that contact and that interface. So we encourage e-filing, and of course, for those who have access to the courthouse information access system, after something is stamp filed and scanned into that public access system, you can always print your date stamp copy yourself through that modality. So that works well too. And Laura, I should say, on behalf of Chancellor Lyle, she wanted to be a participant in this town hall meeting today with all of us, but she had a hearing previously scheduled, and she's engaged in that right now. That's ongoing.
Well, and
So
Chancellor,
with her apologies, otherwise she would be here with us.
I was going to say Chancellor Lyle is actually a member of the NBA board, and so she's actually given us a lot of insight over the last few weeks on what's going on at the courthouse. We appreciate her very much. I have our first question from the gallery. Do you have any suggestions of best practices for lawyers appearing via phone or video? And we'll start with Chancellor Martin.
So it's interesting. The first hearing that I did, one of the lawyers was sitting in front of the laptop and one of the lawyers was standing in front of a phone. And I think having a stable device, and this sounds sort of rudimentary, but it's something we've all figured out over time, having a stable device and having, and staying still and not moving backwards or forwards towards the computer in terms of the video and the audio is very helpful. Having a background that's not too busy or distracting can be helpful. I think those are primary things that I've picked up, and then making sure you understand the technology and how to get on. We're not going to punish anyone for sort of figuring it out as they go, but it does improve the presentation to have those kinds of things sorted out before you start.
Chancellor Perkins, do you have anything to add?
No, I agree. Nothing to add.
I would just add, be sure you know where your mute button is. And if you're not speaking, it's helpful. It really cuts down on the background noise to hit the mute button. I've heard a number of dogs and little ones who have participated in some of the hearings, and it's always helpful to hit the mute button while you're not speaking.
The other thing I'd say and I'm learning as I go, but the video conference that I had that I live streamed, I had 17 lawyers on. And what I tried to do was to sort of call on people. And also at the beginning of the hearing, even though we had everyone's faces, it was, I wanted to know who was on representing what party. And I beforehand made a list of all the lawyers who had made an appearance in the case and who they represented. And because I didn't want to mess up and not recognize someone or not understand who was on for a particular party, I would start off and say, and these were 2 cases that I was hearing together. It's sort of complicated, but anyway, I would say, so on case whatever, who is here representing this particular plaintiff? And then I'd have them go through and do a roll call and check off for myself who was there, so I didn't get that wrong. And then when I was hearing from the parties, I was trying to go in order or sort of call on people because that seemed to be an orderly way to do that. And that's more from the judge's perspective, but I think that's helpful to know if you're in a complex case with a lot of different parties. I think that's the way to organize it. And to also, we had a court reporter on that one, so it also helped the court reporter, I think, know who was speaking. And also, one more thing, when you do get on a Zoom or a WebEx, if you have an identifier for yourself on your computer, make sure it's not your kid's name or your wife's name or something silly. I mean, because people do want to know who you are.
Speaking of silliness, we've seen some news reports about lawyers appearing in different courts lying down in their bed or without a shirt on. 2-part question. Number 1, have you had any major Zoom fails since this has started? A cat going across the screen or anything that could add a moment of levity? And then the second question actually comes from our gallery, which is, should counsel wear a tie or jacket when they're appearing by video conference? Chancellor Perkins, would you like to start?
Well, this is actually my first video conference, so I haven't encountered that. I don't think necessarily this is just shooting from the hip that a lawyer has to dress as if they're getting ready to go to church or something, but they should be respectable. They should be covered up.
Clothing is recommended.
Chancellor Moskal.
I don't have a strong preference. I think it's always good to approach it as if you're going to be in court. I think it just puts you in the right frame of mind because it is a court proceeding, and in my courtroom, we are recording in the courtroom all telephone conferences and video conferences. And I am physically in the courtroom on the bench with my Part 1 staff, and we are recording the conference. So it is a formal proceeding from my perspective, and that's something that I think the bar needs to know. And those recordings, of course, are available should they be needed. And I would add that with like summary judgment motions or temporary injunction hearings that are being heard without evidence, I have had requests from counsel if their clients may attend or other interested parties. And of course, we are sharing that information with everyone.
Chancellor Martin, any Zoom fails or recommendations on clothing?
No, you know, we have all let our normally dapper attire slide. Today is as dressy as I've been in a while, frankly, because of this. That being said, I mean, it is a respectable court proceeding. I record as well. I think people want to put their best foot forward. Do I think that people have to have on a suit and tie? Not necessarily. I don't think people should show up in a golf shirt either. So I think that people should use their judgment, but these are strange times and we're all adapting, and I am too.
One question that I have for you is how much communication you're having with the Tennessee Supreme Court on how your procedures have adjusted, and how much guidance are you lending to the court in how they construct their next order? And then from the gallery, kind of along those same lines, do you think that the Supreme Court's next order will provide different rules for Nashville and other metropolitan cities?
Well, I'll jump in. I think the Supreme Court has done a fabulous job of leadership, and the Chief Justice, Jeff Bivens, has. We have had weekly telephone conference calls with all of the state court judges, and that's been incredibly helpful for the court to keep us informed, and also to hear what problems are being encountered and in a telephone conference setting, to hear how different judicial districts are handling some of those issues. The Supreme Court has also been very receptive to suggestions from the trial court and appellate court judges as to what is working well and where we need help, and very responsive to those needs, including securing laptops for all the judges and VPN access. And so it's been, I think, really excellent.
Chancellor Martin, anything to add to that?
Well, and most recently, what happened in this past week is that the Supreme Court set up a special email address to take input to judges as we get to this opening up time or phase of things, of special concerns or interests or issues that we wanted to direct, because we get on these calls and there's, 150 state trial court judges, and you have everybody from, Anderson County to Shelby County. And that's not really intended to be a forum as a free-for-all, but we've been able to email in our thoughts, and what's going to work in Davidson County is not necessarily going to work in Rutherford County or in Sullivan County. And so particularly where we are all in one courthouse and in one courtroom or one chambers, hearing particular kinds of cases versus our colleagues who travel a circuit, or who hear criminal one day, domestic one day, and general civil another day. And so the court is doing a great job, I think, of giving us guidance and clear guidance, but also giving us room, and has really asked each district to make a proposal about how to deal with reopening. And so all of the districts are going to be working with their presiding judges to come up with a plan that is particular to those districts.
Chancellor Perkins, anything to add to that?
Nothing to add. I agree with what they said.
I have another question from the gallery, and I'll read it to you. I know the courts have worked hard to keep proceedings open to the public, even when holding telephone and video hearings. Can you tell us about how you're handling that in your courtroom? Chancellor Moskal, would you like to start?
Well, I've not had a request to make mine available to the public, but any request that we've received from someone, even if they're just an interested person and not necessarily a party, we have provided that access number so that they can listen in on the proceeding. Chancellor Martin actually has had experience, so I'll defer to her on that because it worked great.
This was what I was referring to before. We had a press request for an upcoming hearing, and we had to work with the technical folks about what format, what application would work with a live streaming. And so we ended up using Zoom, and we could set up a YouTube live stream to live stream the proceedings. We all have assigned video, or we all have assigned phone numbers and can get a WebEx video conference for our particular proceedings, and anybody can contact our calendar clerks to participate, because everything we do is open to the public unless it's a particular circumstance otherwise. But making it generally available to the public, the live stream option seems to be the best way to do that. And because some of the things we hear in Davidson Chancery are of particular public interest, we have figured out a way to do that. And at any one time, any of us is hearing a case or has a case pending on our caseload that is of unique public interest. So that's available if we need to do that. And those requests generally come through the Clerk of Master's office and will be routed to the judges. What we haven't had yet is a request for cameras in the courtroom. As a typical matter under the Supreme Court rules, that request has to be made and the parties have to be notified and the court has to decide whether that's the case. And then there are different ways to limit cameras, or to have a, I forget what the technical term is, but essentially to have one camera in the courtroom and have it streamed to or tied to other cameras that are not in the courtroom. Those are all challenges that we're going to face, I'm sure, in upcoming months as we open up, but try to contain social distancing.
And Chancellor Perkins, I know this is your first video conference, so I'm guessing you haven't live streamed just yet in your courtroom, but let me ask you another question. Have you seen an increase in certain types of cases in your court with COVID-19? I know that that raises issues for individuals and businesses, and I'm curious whether any types of filings have increased.
Not yet. It seems to be the same particular kind of mix. Usually about half of our cases are breach of contract in some form or fashion. Of course, that includes construction or fights over a music publishing contract. But with part 4, the part where I work, is seeing a distribution that's normal. But you know, in any court, there's an ebb and flow. So sometimes you get hit with a lot of emergency matters. Sometimes you have 3 or 4 high-profile matters with expedited schedules at the same time. And then sometimes there's a lull in those high-profile expedited matters. So from what I can see, we're about at a normal pace on that.
Has that been your experience, Chancellor Martin?
Yes, I haven't seen anything out of the ordinary. I think that new filings are a little down. I would defer to the Clerk of Master on that, but they're probably a little down just because everybody's figuring out how to do things. And I cannot imagine how difficult for practitioners it is, communications with clients and trying to prioritize and where to spend money and what's on fire and what's not on fire. So I just think that natural chaos has affected the filings, but I'm not seeing any type of case out of the ordinary.
Chancellor Moskal?
I'm seeing the same thing. It's, I think it is a little down, and but I think people are figuring out how to take advantage of the technology to start pushing things forward. I understand that there was one insurance related lawsuit filed challenging business that was in the paper, bringing a insurance claim that had been denied for business interruption insurance related to the COVID-19. I think that one got filed in circuit court. So, but that, I think that's the first one and the only one I've heard of so far.
I'm going to take a quick pause just to remind everybody on the conference that if you have a question to pose to the chancellors, if you'll use the chat function at the bottom of your screen and send your question across, and I'll make sure that it gets asked. My next
Can I say something else? Can I say something else before you go?
Of course.
When it comes to an emergency matter, we pride ourselves on, you know, dropping everything and trying to get to it. But because we have less staff available and we're trying to keep them safe, the turnaround time could be a little bit slower. So if something comes up and say there's a press request, and instead of just perhaps directing it to the calendar clerk, you should also direct it to Maria Salas. And if for some reason, I doubt there would be a delay, then we also have our trial court administrator, Tim Townsend, available. And he's heavily involved in press requests also. So, you know, emailing more than one person would help when you have an expedited matter.
The mayor just released a 4-phase plan for reopening business in Tennessee, or in Nashville, I guess. And I have a question from the gallery. Even in phase 4 of Nashville reopening, those over 65 are to remain at home. So the question is, are online hearings here for a while, at least if a lawyer or litigant is in that category?
I think we've all developed a skill set that we didn't know we had, or we've had to figure out. And I think that there's going to be a number of ways that this is going to be beneficial. It's not like suddenly we're going to go back to the way things used to be. I think people are going to be cautious. I think there are going to be different levels of comfort being in the public and being in public spaces. I think that it is a terrific business tool with the complex litigation we see with ProHoc counsel from out of town. I think it is a great way for people to participate in an efficient, cost-effective way and to be present, you know, physically present or virtually present, I'm sorry, without being physically present. What I think we're going to have to do is balance it replacing everything, or people wanting it to replace in-person hearings, because I do think there are things that you miss. And I think we're also going to have to deal with different preferences among lawyers. It's not going to be the fallback or the only option or the exception either. I think all of us judges are going to have to balance how much of that we let go on, who makes the call, what's going to be video versus in-person versus phone. I mean, ultimately we make the call on everything, but we all used to be lawyers who practice, so it's not like we're, you know, I'm not trying to cram any particular technology down anyone's throat, and I want people to be able to practice in a way that makes sense for them, makes sense for their clients, makes sense for the case. So I think that's going to be an adjustment.
Laura, I'd like to just mention to members of the bar, and I'm going to have to drop off in just a moment, but there's a lot of really great information on the Clerk and Master's website. And there's also a feature on the website that is Contact Us. And I want to assure the bar that Maria Salas, our Clerk and Master, I join Ann in saying she's doing a fabulous job. She monitored that function. And so the bar should feel comfortable using that if they've got questions, or if they have an emergency filing and want to give the court a heads up that something is going to be filed, so that we can be alerted and be prepared for it. And I just encourage everyone to use that and to communicate as much as they can.
We thank you all very much for your time. Before you drop off, Chancellor Moskal, let me ask this question of the panel. We've all probably experienced people asking during this time about silver linings. Do you see any silver linings in our current situation, or is there anything that you're particularly grateful for right now?
Well, I'm tremendously grateful for our staff, and particularly our IT staff, who have helped all of us get up to speed very, very quickly using technology to continue moving cases forward and the court's business forward. And we have all learned new skills, as Chancellor Martin mentioned, and so that has been a silver lining, and I look forward to continuing to take advantage of those resources.
Chancellor Martin.
I mean, obviously figuring out this kind of technology and knowing that we can do it, and that it's not as hard as we all thought it was going to be, it has been a silver lining. I also think how much everyone is working together. we are all at our different offices rotating staff. Some are working totally at home, some are working part at home, part not here. And I really appreciate how flexible everyone is being, and how everyone's, rowing the same way, and everyone is focused on keeping the court's work going and doing good work, and appreciates how important it is that the courts continue to function and be open, and that the public appreciate and understand that, especially during times where people are incredibly anxious and uncertain and nervous.
Chancellor Perkins, any silver linings?
Yes, as indicated by my colleagues, this is an opportunity to be more collaborative internally between clerk's office, our teams, and also with lawyers, because lawyers have an obligation to try to work out logistical and scheduling things, and now that is going to spill over into situations where, well, do you actually need an evidentiary hearing for that? Can it be a hybrid hearing where maybe part of it under Rule 43 is by affidavit? If we have somebody who is a party who's over 65, can we have a hybrid hearing and have them patched in through Zoom or video conferencing? And the lawyers are on the first line, on the front lines of working these kinds of matters out and thinking creatively. And the courts always rely on lawyers a lot. So I think this opportunity to focus on what's really important in a case, what really cannot be resolved through collaboration, et cetera, is important. And so that will streamline. I mean, maybe we will have less disputes about logistical matters because everybody knows we're kind of in this unusual moment. So that's what I think.
If I can squeeze in one more substantive question before we bring this town hall to a close. In Executive Order 26, the governor has allowed notarizations to take place remotely, even beyond the Online Notarization Act. Have you seen or do you anticipate any problems with documents being notarized because of that order? Chancellor Martin.
I get this one first. I haven't had it come up yet. In Chancery Court, a lot of what we see are sworn statements because we do so much on the pleadings, and because people can use declarations versus the traditional affidavits, the availability of a notary has become less of an issue than it used to be. I was a notary for years, and I cannot tell you how many times I went to see witnesses to get notarizations, and you met people wherever you could because you had to get that. So with the ability to use declarations, I think that is less of an issue for us. I think initially the thought of the online notarization, in particular for people doing estate planning, that was really critical, and people were feeling the need to have their sort of affairs in order, and that was the importance of having that available. I have not seen it affect what I'm doing yet. I suppose I could see it as an issue if there's some question about custodian affidavits or custodian notarization or custodian certificates or something like that, but it really hasn't come up yet. And that would be more typically in an evidentiary hearing in terms of documents being submitted as business records or something like that.
It has not come up for me either yet. I'm seeing a lot of declarations in lieu of affidavits, which is perfectly fine and permitted under the rules. And Laura, I just want to say thank you for including me in this town hall. And I think this is a marvelous service to the bar community. So I appreciate the National Bar Association doing these town halls. And I need to sign off, but you all continue. Thank you so much.
Thank you for being with us. We appreciate you giving us your time today. Chancellor Perkins, did you have anything to add on the remote notarizations?
Not really, but where it might end up needing to be used will be in the TRO and temporary injunction context. And because if it's not sworn, we can't grant extraordinary relief.
Well, with no more questions from our gallery right now, and we've been going for 45 minutes, we really appreciate all of your time today. The Nashville Bar Association is grateful to all of our judges and our chancellors for helping us to communicate with all of our members about the different changes in your courtrooms. And thank you for giving us your time today, and we'll bring this to a close. Thank you.
Thank you.
Thank you.
Very much.